What is going on, everybody? It is Complexity, and today I'm bringing you a new video. This is when an attorney who advocates for his client goes at it 2 days with Judge Fletcher, or Fisher, sorry. If you don't know who Judge Fisher is, he's a pretty well-rounded judge, very fair, very, forgiving and understanding. But at the same time, he's a no-nonsense judge, and you gotta love judges that are like that, judges that'll listen, and you gotta love an attorney who's willing to fight for their client, especially when it comes to the law. Now, one thing I will say is that, hey, sometimes criminals might get off due to the fact of a very good defense, but at the end of the day, it's about the law. It's not about what we know, it's about what we can prove. So let's get right into this video. I did skip a little bit ahead because there was some preview to it, but let's get right into this.
So let's go.
So it sounds, if I'm not mistaken, this is a probable cause hearing, which means that they're trying to see if there's enough probable cause to move forward with the actual indictment on this person or with the actual charges.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed
located.
what?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers...
Okay, so far we have two conflicting issues here. First and foremost, the officers so far have not witnessed a crime. So yes, they have the ability to make their inquiry. They have the ability to ask questions because it was a report of a potential domestic, but because they did not witness it themselves, there's not like they're investigating the possibility of a crime. They're not truly investigating a crime in and of its own. Now there's verbal confirmation from this guy that he said that he would physically assault the girl, which does lead them to have the more ability to investigate more, because now there's a potential that there was domestic violence that had occurred or could occur if they leave.
Advised the defendant that he was in custody for an outstanding warrant. He got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them.
That's true.
I understand
And they're a 0.1 mile away from the location.
So
For what?
Well, okay, I get that. But so we've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, hey man, I'm going to slap her. So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause.
So the lawyer so far is arguing the fact that they're charging him with interference of public duties, which means that he was stopping the officers from being able to do, their job. Now, he's saying that it's possibly a resisting arrest charge, pushing off the officer, going a plank, not being willing to get inside the vehicle, which would be resisting arrest. Now, is it interfering them from doing their job? Is it interfering them from doing their investigation? Now, in almost every single state, if I'm not mistaken, every single state, you are not legally required to speak to police officers, so that can't be seen as interference with public duties.
That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate.
And that's what I was talking about earlier. The moment that, that statement left his mouth, there is the potentiality of a physical harm happening due to after they leave.
They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because
And that's exactly what needs to happen here, right? Because instead of the judge simply turning around and saying, I know the law, this is the law, I'm going to just go on with it. If no proponent party is understanding or has the believes they know exactly what it is, they should bring out the law. Now, as far as interfering with public duties, interfering with the investigation, that would be more so like it would be more like if you were hiding information, or if you gave false information, or if you obstructed justice in a way of getting rid of evidence or something like that. But is him resisting arrest interfering with public duties?
I mean, there's no better way. Let's read.
Or potentially resisting arrest?
Hold on.
I'll give you. All right. Hold on. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have
Okay.
taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on.
And that is true.
If-
If you put your hands on a police officer, even if it's just a push, whatever it might be, it is immediately assumed to be assault on a police officer. Even if you spit on an officer, it's considered assault on a peace officer.
they didn't
Hit.
they took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says, because there's multiple ways that a charge can that you can charge someone with facts, right? There's multiple ways that can. You're right. It could have been like a resisting, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
the cop can claim anything is interfering with public duties. I mean,
And that is one of the issues when it comes to a lot of laws. A lot of the time they are written very vaguely in an effort to go ahead and basically be an umbrella to where officers pretty much have almost at their discretion with some certain laws with the way they're written to be able to have it fit in certain areas. So it would be up to, like it says here, it sounds like the charge could fit with the judge's discretion. So, and a judge has a lot of power when it comes to interpreting the law, when it comes to interpreting what the law means and how it should be applied, if it's applicable or not. So it really is up to the judge to decide whether or not the charges hold any weight. And not a lot of the time, but it is possible for a judge to turn around and say, look, the charges that you're trying to charge this person with just don't stick as far as my belief, as far as my understanding of the law. You need to come back with a different charge, like resisting arrest, possession of marijuana, et cetera, et cetera.
I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point.
And it does make you wonder, why is it that they didn't charge him with assault on a peace officer? Why is it that they didn't charge him with possession of marijuana? Why is it that they didn't charge him with resisting arrest? Why did they go with the vaguest possible charge? You know, it's a little weird.
I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance.
So the reason why the lawyer is arguing that is, if they didn't have enough evidence or enough of a probable cause to even run his information, then the fact that he has a felony warrant gets thrown out the window. Because if it wasn't enough probable cause to run him, to detain him, to arrest him, or anything of that nature, then it's what's called fruit of the poisonous tree, right? They don't have the ability to enact the arrest in and of itself. So anything that they find out after the arrest needs to be thrown out as well.
Chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess, did they put him under arrest at the time when he said that he was making that threat?
Which is very important, because if they put him under arrest prior to him making that statement, it means they had no probable cause to arrest him in the first place, which would be breaking constitutional rights.
And with being
I mean,
0.11
did they have the authority to arrest at that time?
Which
Right.
is the
I think it was
most
during
important thing.
their investigation, the defendant admitted to threatening, that he would slap the Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist. That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just
I
saying.
don't know if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
We also
And
don't
yes.
have the offense report
We
yet,
don't
I
Judge.
have
don't care. I mean,
He was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
So it sounds like a resisting arrest, whereas interference with duties, I mean, resisting arrest sounds like it would be a nail, a nail in the coffin there. Like it's an obvious resisting arrest. He's going plank. He's pushing off the officer. He's refusing to put his feet in. So it makes you wonder why they went with such a vague term or a vague law. Now, sometimes officers will do this just simply because they don't want to run the risk of the case being thrown out if it's determined to not be resisting arrest, right? Let's say that they said that's what happened on at the time, but when they reviewed the police camera, it doesn't actually show what they're saying, or it could be interpreted very differently, which is one of the reasons why they might have gone with a more vague statute.
I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
Remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way.
Which is
Like
true.
you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
It seems like more so that that law would cover, like what the Judge Fisher just said, if somebody was to have come up to the police officer and like try to stop them from arresting him, that would have been interference with public duties, right? Whereas with him just going plank and not wanting to be arrested would be resisting arrest.
For to me, because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
Called 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, you know,
I mean, because
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all.
And that's a fantastic way to be as a judge. You always want your judge to be be open-minded. You want a judge that's going to be fair, because this judge could, I mean, it sounds like neither the prosecution nor the defense has been able to see the body cam footage yet. And the judge could have very easily have just said, fuck it, whatever, we're moving forward with this. Like, I don't care. Yet make it to, go to trial. And then the body cam footage shows something completely different. And now you've wasted this man's time in prison. You've wasted taxpayer money, and it doesn't look good on the prosecution. So considering it seems like nobody, even the judge, has seen the video yet, it's good that he was willing to roll it into another day. So that way everybody could be as on the same page as possible.
All ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
A PR bond is a personal recognizance bond, which means that you can leave the courthouse, you can leave custody without having to put anything up. Whether you don't have to put any bond up, you don't have to put a cash deposit down, and you don't have to put like your house or your car or something. Typically, a bond is 10% of whatever the overall thing is. So if it's like 50,000, you have to put up something that's worth 5,000.
Okay. Well,
The bond right now is set at 2,500.
Okay.
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case.
So that's 7,500, which means that in order for him to be able to bond out, he'd have to be able to pay 750 or put something of equal value or greater value.
Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can.
Probation is like, man, you could fart wrong and they're taking you back to jail. If you're on probation, you can't be associating with any criminals. You can't even be in the vicinity of any criminals. You can't be in the vicinity of paraphernalia, weapons, anything of that nature, especially a felony probation. Boy, you might as well just stay your ass at home and freaking DoorDash everything, because it's not worth risking, because you could trip and fall into the jail system at that point.
You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you,
Yeah, absolutely. Some people will stay in relationships, whether platonic or romantic, that is just nothing but a net negative for them and will continue to bring them down. And a lot of the time, people, people do that, people will choose to go ahead and be with this person because they're so wrapped up in what was or what could be. And they just end up making terrible, terrible decisions.
Just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday, what in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want.
Good.
Sure.
Good. The judge was down with that.
Do you have it?
We have the camera, the body cam.
I just shared.
Okay,
it.
so
They
let's-
shared it. They just shared it with me.
Yes.
let's roll this to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes
Fantastic,
now,
Judge.
I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay. All right, Mrs. Zenon.
Okay, come on.
See you tomorrow.
See you tomorrow. Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed.
A sealed warrant is a little odd because typically the only time something becomes sealed is in order to protect a person's identification, so some party proponent to the case, or it's already done and over with and it got sealed like on someone's record. So that's a little odd.
Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge,
Wow.
but the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes,
So it was allegedly committed prior to, now nevertheless, it's still a
it
warrant,
was.
but how on earth has it never been?
It's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation.
Yeah, this isn't making a whole lot of sense. Like, how is it that you have a felony assault warrant that's sealed, and then you're only going to unseal it once the person is arrested? So it's like if that person never got arrested, they could have very easily have been rolling around with the felony warrant, for decades, like literally decades. So I don't know. It's a little freaking odd. I have no idea why it is that it's a little shady, because imagine walking around with a felony warrant and having absolutely no idea that you have this felony warrant, and you get a traffic ticket, and next thing you know, you're getting arrested and going to jail,
He's been
for something that happened like a decade ago.
meeting with his,
Stating in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that, and another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never.
So he caught multiple cases where he was arrested for something, and yet the felony warrant was never enacted, most likely because it was sealed, and because, most counties don't commingle, like it wasn't just being enacted upon all of these different arrests, which is insane.
I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge,
And this has been going.
So what the lawyer is arguing is that what they believe is that basically the person would go to jail, spend their time, and then once they get out of jail, in order to pat the statistics, they would then enact the felony warrant and revoke their parole and have them be sent back to jail or to prison, whichever it is that they do their time in.
Went on for years.
Oh, well, jail is basically where you're being held until you go to prison. But yeah, so once they get out of prison, basically holding on to the warrant, they get out of prison, they were, revoke parole, enact the felony warrant, and they send them back to prison.
Out there, like prior administration continuing.
But I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's going to look and see that was like extremely old, right? I would have the first time he failed.
I'm not gonna read it. It doesn't matter.
As in,
I mean, it doesn't matter. It's on video. It doesn't matter.
Okay.
Parents required, but
correct.
if he pays.
On video, guys. Like, I watched it. I'm not crazy. Like this, it's on video.
Sorry to keep
Let's
debating.
talk to Judge about it.
Okay.
It seems like the lawyer is pretty sure that he's going to be able to get his client off because the video isn't matching what's being said on the paperwork.
Still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
Well, so what he's saying is basically if somebody believed that it was unconstitutionally vague, then a lawyer would be able to challenge the case law in and of itself, where they would take it to the Supreme Court and have it be changed. And it's happened a couple of times, but it's also entirely possible that, the people have tried to take this to court or to the Supreme Court and it's just been shot down. So, and when that happens, then the ruling stands on what the the statute is and how it is, whether you believe it's vague or not.
and, I'm happy for you to make new law, always. Why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car,
They want to argue.
they need help, right? They're unable to do it by themselves.
And it's entirely possible that like he's got his hands behind his back like this, and what he's doing is he's going forward and he's like talking to him, which would then have them push, the person who's arrested into the vehicle. So it's entirely possible that's what it was, like that's what was taking place. And that's why they weren't able to really get him on resisting arrest, because they looked at the body cam themselves, but they were able to file it under an incredibly vague statute, which would then, basically save their ass and at least let them be able to charge him for something.
Is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cops.
Yeah, and see, that's exactly what I'm saying. It sounds like they didn't even know what to charge him with, so they just threw it. They used the vaguest one possible, so that way they could cover their asses with the charge because he's been arrested. So once he's been arrested, they have to charge him with something.
Sitting there, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA Officer Singh. It's a 27-minute video. Okay. At no point is the DA's office called to this point. Okay. That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay. They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest?
And that's all that it boils down to. If he's impeding, yes or no, because that is the charge they wanted to put on him.
I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Zenon, Your Honor.
Mr. Zenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
At this point, just watch the video.
He was cooperative the whole.
Because all this arguing back and forth is one thing, but once you actually like watch the video and see and you know you compare it to the facts on paper, that's what will really determine it.
Time, Zenon is mom. If anyone's aggressive, it's the cop from the beginning.
Judge,
And I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
We can watch the video, Judge.
Cue it up. Let's watch.
There you go. Put it all to bed. Watch the
Can you put it
video.
on the screen somehow? So we can all watch?
we can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology. The whole video, or did you?
No,
want to-
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you want to just put it right there and just turn it around.
Yeah, just put it
Just
up
right
there.
there on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let them pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him. Now you're under arrest. I'm under arrest. Yep, you charged, Bubba. Resistant transport. Resistant? I wasn't resistant. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge.
Yeah, there you go. See, it's all that matters, man. You can do all this talking. You can say all what's on the paper, your interpretation, all of it. But the video never lies, man. The video never lies. That's why I said the fact that the judge took the time, allowed both of the parties to go ahead and take a look at the video and make a determination based off of that. Chef's kiss.
Come on.
Thank you, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
There you go.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
So the judge is basically saying, look, if you want to file under resisting arrest, Shane, go for it. If you feel you have a strong enough case for those filings, go for it. But as far as impeding, nah, it ain't it. It don't smell right. It don't pass the smell test,
Nope.
My name is Bennett and I ain't in it. But
Which is fantastic. Kudos to the judge. Kudos to the judge. He very easily could have turned around and just been like, nah, like, I don't care. I don't need to see the video. They'll see it at trial, blah, 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 blah. We have all of these warrants out, or we have a warrant. We have all these different open cases on the guy. Just send him away, whatever. But the judge chose not to do that, which is awesome. Kudos to the judge. Kudos to the attorney, fantastic attorney here, wanting to go ahead and advocate for his client over 2 days, not letting this go, and being even more, got a fire under him and in his belly once he actually saw the video. And you could tell too, look at the smirk on his face. He's just like, yeah. But that's fantastic. You love to see it. The criminal justice system, with all of its many flaws, there are people who are in it to actually enact justice. And it's fantastic that there's judges like this still out there. It's amazing. It's fantastic. And I love every minute of it. I've been Complexity, you guys. Hit that like and subscribe button. Leave a comment leave a comment down below as to what you think about the video. Do you think the judge made the right call? Do you believe, that justice was served here? And, just tell me what you think. And I will catch you in the next one.